Good afternoon. Today is Tuesday, January 23rd. This is the Finance Committee. We'll have two briefings today. We're going to start with the Workman's Comp Commission 101. And I ask that Commissioner Maureen Quinn, Commissioner Chair Maureen Quinn, come. And if you'd like to bring Mary Ahern and Linda O to the table with you, you may.
Yes.
And following this presentation, we will hear the update from the Prescription Drug Affordability Board. So thank you, Chair Quinn, for being here.
Okay. And my microphone is on. Yes, it is. Thank you. Good afternoon, Chair Beidel and members of the committee. Thank you for the invitation for this briefing. With me today is Mary Ahern, our CEO. Mary will be retiring on May 1st after 25 years of exemplary service at our agency. And also with me is my colleague on the bench, Commissioner Lynn O. And I'm glad she's here because I'm going to be asking you to appoint Commissioner O to the Joint Oversight Committee on Workers' Compensation, as I must resign my seat now that I am chair. So as I embark on my second year as the first woman to chair our agency in its 110-year history, I'm mindful that I too have devoted most of my professional life to this agency and its mission. I am in my 22nd year of employment. My first 20 years were spent as a commissioner, and the commissioners are the trial judges of the workers' compensation system. So my remarks are 25 minutes in length with time for questions and answers, and I'll speak in three parts. First, a bit of autobiographical information so that you know a little bit more about me than, oh yeah, she's the wife of Kumar. Which is not a bad gig, by the way. Second, an explanation of the judicial part of our quasi-judicial agency with an emphasis on features of workers' compensation law that I think will help you best understand and scrutinize the bills that come before your committee. And third, I'll discuss the executive agency functions over which you have oversight. And I'll report on our vacancies and our rebuilding state government efforts. So I don't have a lot of data to present, so I decided against PowerPoint slides. I've delivered a copy of our 2023 annual report to each of you. So if you should have any questions arising out of the data in that document, Mary Ahern will address your questions. But just one interesting note about our annual report on the cover, you will see all women workers this year, including Commissioner O, who was a firefighter for a day. So you can see her picture there in her firefighting uniform. We like to have fun at the commission. NCCI by law provides this committee and the commission with a lot of economic analysis every year. And what we were told this past year is that the workers' comp insurance industry is strong and competitive. And a healthy workers' comp insurance market is the greatest gift that I can envision, both for injured workers and for the business community. Later last year, NCCI recommended a 10.4% decrease in premiums this year, which is large, but it continues a 14-year downward trend in rates. So it's against this backdrop that I offer my remarks. I've brought three pieces of paper, which I think were also electronically delivered. The first is a docket sheet used at hearings. The second is a workers' compensation claim benefits flow chart. And the third is an actual permanent disability award of the commission. I am mindful this might be the only opportunity I have to tell you about my life experiences and how they've shaped my opinions. Each of you can look up my resume on LinkedIn, but I wanted to share something a little bit more personal. 3 of my 4 grandparents only went to the 6th grade. They were immigrants from Ireland, and they were housekeepers and janitors, mechanics, and cafeteria workers. My parents were determined that we would all go to college. My mother couldn't go because her parents couldn't afford to, but my father earned his college degree at night after 7 years of school while working full-time and raising 6 children. I've worked on factory assembly lines, I've waited tables, I've delivered newspapers. And because of my parents' love and singular focus on education, my personal and professional life has turned out great. and I am proud that I've been able to enforce and protect the rights of both injured workers and the business community from the bench and now in my role as chair. Let's turn to the judicial part of our quasi-judicial agency. We have 10 commissioners, 9 of whom take the bench every morning in our 7 courthouses. I am the 10th member, and as chair, I hear dockets only to the extent practicable given my other duties. Most often, that means I fill in for sick commissioners so I can save the commission money by hearing a docket rather than paying a retired commissioner to come in and hear it. We are all appointed by the governor with the advice and consent of the Senate, as Senator Vital well knows. Our courthouses are located in Cambridge, La Plata, Beltsville, Baltimore, Abingdon, Frederick, and LaVale. I invite each of you to contact me if you wish to sit in on our hearings. You will see that we operate much like the district courts. We handle a high volume of cases. We rely heavily on forms. The rules of evidence are somewhat relaxed, and we don't have live testimony from doctors. Rather, competing doctors submit their written medical reports. 99% of all the people who appear before us are represented by an attorney. We issue orders within 6 days of a hearing on average. We are one of the fastest, if not the fastest, in the nation because of one feature of our system that we should never wreck. We don't have to write long legal opinions. Yes, we like that too. Our orders respond to the issues presented with the words approved, denied, or a sum of money. If we had to write long legal opinions, as some states require, injured workers would lose their homes and everything else they own waiting for a ruling. Speed is the lifeblood of our work. Our appeal rate is 7%, a number that I think demonstrates that quality is not compromised by our speed. So on your desk, I've placed a docket sheet from our La Plata hearing site. It's the top document. And I've offered this to illustrate what it is that we do. This is a typical docket from a typical day. And our hearings, like all courts, are open to the public. And these docket sheets appear on our website daily. We have court reporters and security. Our decisions, if appealed, are appealed to the circuit courts. Looking to this docket sheet, you will see on the right-hand side a 1, 2, or 3 designation. These numbers correspond to the 3 types of cases we hear and the types of cases that have bills that are before your committee. So, turning first to cases marked number 1. These are cases that are contested because the employer is arguing that the employee wasn't injured at work, that the worker was an independent contractor, the statute of limitations has run, or some other legal defense that bars the claim. And this includes death cases that are contested. There are 2 ways to get hurt at work. You can have an accidental injury, or you can suffer an occupational disease. Take a look at the benefit flow chart, which is the second document, and you will see on the left-hand side both types of injuries enumerated. Examples of accidental injuries include slipping and falling, lifting something or someone too heavy, or a motor vehicle accident. Examples of occupational diseases are carpal tunnel syndrome, cubital tunnel syndrome, certain cancers, PTSD, and hypertension. Allow me to add a little bit more complexity to this. Some medical conditions can occur as a result of an accident or an occupational disease, and 3 examples will be very familiar to this committee. Hearing loss can happen as a result of an accident. Suppose a police officer has an explosive device go off in her ear during a raid, and that event caused permanent hearing loss. That hearing loss occurred as a result of a one-time event, so it is considered an accidental injury. Alternatively, hearing loss can happen slowly over many years of exposure to loud factory noises, as was experienced by Beth Steel workers. A second example, a cashier at 7-Eleven or a bank teller can develop PTSD as a result of a terrifying robbery at gunpoint. That is an accidental injury because it arose out of a one-time event. Alternatively, PTSD can develop slowly over many years when a first responder is exposed to countless tragedies that ultimately cause a mental health crisis. One last example. Last year, this General Assembly and this committee recognized a sports hernia as being an occupational disease. This was groundbreaking in that under prior law, all hernias had to have happened suddenly as an accident to be compensable. Now, they too can happen suddenly or over a long period of time. The benefits paid out under both these types of injuries are the same, but the elements of proof are different. Occupational diseases require a worker to lose time from work or have a change in duty status before a claim can even be filed. And this requirement is known as the disability prerequisite. Let's talk a moment about the exceptions to this lost time requirement. You can file for occupational hearing loss without missing time from work. And that, of course, just makes common sense. You don't need to stay home from work just because your hearing is bad. You had a bill last year that didn't become law, and I believe it's coming back before you this year. That bill removes and alters the loss of work requirement for hypertension. The rationale for this bill is the same as hearing loss, in that no one needs to necessarily miss time from work just because they've been diagnosed with hypertension. Typically, your doctor puts you on medication and back to work you go. Of course, the commission is neutral on this bill, as in most situations, but I wanted you to see the parallel under law. I'd like to talk for a moment about one aspect of presumptions, which I hope will be useful to you. I spoke with a legislator last year, not anyone on this committee, but the legislator thought that a presumption law meant that the workers' comp claim was automatically accepted and that the afflicted worker could immediately get medical treatment and lost wages. I realized then that while that was a mistaken belief, it made perfect sense that a person would think that that's what a presumption law would mean. So this experience prompts me to just spend a moment letting you know that the counties and the state routinely fight presumption cases in our courtrooms. They are not automatically accepted. The presumption law merely gives the worker an evidentiary jump start, if I can call it that, because the law presumes that their cancer arose from their firefighting, and then the county or the state must prove otherwise through evidence. The most frequent types of evidence we hear is that the government will show that the heart disease or the lung cancer stem from a family predisposition or from decades of smoking, for example. At contested hearings, sometimes an employer has no workers' compensation insurance. And in those cases, the UEF, another agency regulated by your committee, has its lawyers at the table defending the claim. The UEF can present any defense the employer could raise. For example, suppose a worker says that he was in a car accident while on a sales call. But the employer's defense is that, well, no, actually the worker was running an errand and buying his son's birthday cake at the time of the accident, so it's not work-related. Our job as commissioners is to hear the evidence of the parties and the witnesses and decide who we believe. And in a case such as this one, the UEF can raise that personal errand defense even if the employer doesn't show up for a hearing. Let's turn our attention now to cases designated with the number 2. These are cases in which the worker, called a claimant, not a plaintiff in workers' compensation, is seeking medical treatment, lost wages, or job retraining, and the employer's insurance carrier is fighting the request. The commissioners receive evidence and listen to the testimony. Then they decide whether the medical treatment is necessary and causally connected to the claim. Lost wages are known by the term temporary total in the statute, and I'll return to that topic in just a moment. I want to note that Maryland law allows an injured worker to see the doctor of their choosing. And that is a feature of our system, which I think we should be quite proud. And we have for a very long time had a medical fee guide, which governs the compensation paid to doctors who provide treatment, and it works very well. As you know, issues that tend to trend in and out of favor before the legislature, and there aren't many trending issues in this part of the law, so I'm not going to spend any more time on this, but I'm happy to answer any questions you have on these issues. Let's turn then to cases designated by the number 3. These hearings occur after a claimant has reached maximum medical improvement, and they are called permanency hearings because a sum of money is ordered to be given to the injured worker to compensate him or her for residual permanent disabilities resulting from the accident. The money is not paid out in a lump sum like you see in a personal injury case where a judge says, well, your disability is worth $100,000 and a check for $100,000 is given to the plaintiff. Instead, in workers' compensation, money is paid out over a number of weeks based on a statutory formula. And to demonstrate this, I've brought one of our actual permanency orders, and it's the third and final document. And if you see the paragraph enumerated, number 2, permanent partial disability, this particular commissioner found that the worker had a 21% loss of use of their right knee. Now, not all of it was related to the accident. She found that 8% was attributable to the accidental injury and 13% was due to a pre-existing condition. The employer has no liability to pay any amount of money on the pre-existing condition. So how that statutory formula works out is that the worker is going to receive $372 every week for 24 weeks. There are 2 other important components of this order I want to share with you, because I know that you fund the SIF and the UEF through an assessment on permanency awards, and you can see it right here. In the first paragraph, all caps, you can see how the SIF is funded. It says this award is subject to an assessment of 6.5%, and that money is to be given to the SIF. And then in the second paragraph, all caps, there's a total assessment of 2% to be paid to the UEF. So that's how your statute, that's how the funding mechanism actually works. And the insurance companies know to write that additional check to the SIF and the UEF. So almost every state in the country pays money out in permanency in the same manner, because most states created their workers' compensation system during the period 1911 to 1920. And nearly all these states adopted the jargon that we still see in use today: average weekly wage, temporary total, weeks of disability. And so whenever you feel frustrated by the jargon, you think, wouldn't it be great to just simplify all this? My only advice to you is to treat it like Alexander Hamilton's financial system. It's very hard to even tinker with, and it's nearly impossible to dismantle. Cases marked number 3 can also involve the SIF, which is there as a party and in its own right, not merely as the recipient of an assessment. So in one sentence, a case in which the SIF is involved is one in which the injured worker was already seriously injured or ill before the accident and is also significantly injured in the work accident. I'll answer any questions that you have, but I won't delve into that topic any further. We regulate how much the injured workers' attorneys can earn in a case. The framework is somewhat similar to personal injury work in that the lawyer doesn't get paid unless there's money from which a fee can be deducted. Last year, we adopted reform regulations that allow for a fee of some kind, no matter how long the case goes on, up to $1 million in recovery, which is a very large award in workers' comp and very rare. So we're hoping that this regulation will prevent the dumping of clients because of fee caps that we had under our prior regulations. One other responsibility that we have is to review every settlement of a claim to make sure that an injured worker's future medical needs are addressed and that workers will not wind up on the doorstep of the government looking for benefits that are rightly the responsibility of the insurance carrier. That concludes my remarks about workers' compensation law and our judicial operations. In this last section, I'm going to talk about the quasi or the executive part of our responsibilities. Many of you probably do know that we are not funded by taxpayers and we receive no money from the general fund. We are entirely funded by assessments on insurance companies who underwrite workers' compensation insurance in our state. The amount that we charge an insurance company is based on the number of employees for whom they provide coverage. If there's money left over at the end of the year, we give it back to the insurance companies. Last year, we returned just under $2 million to the insurance company. This was a very large amount, and much of it was returned because of money that we had budgeted for salaries that were never paid out due to job vacancies. And yet, paradoxically, we have driven down our vacancy rate this past year. We have 115 full-time employee PINs. Today, we have 13 vacancies. When I was here last year, we had 16 vacancies. Our vacancy rate by percentage is 11.2%. Our targeted vacancy rate was 7%. But our achievements closely match what other agencies have done. That is, they've gotten halfway to their target. I know this because the governor's office maintains a dashboard which shows the vacancy data for all state agencies, and we can see how other agencies are performing. So we reduced our vacancy rate from 14.6% at the beginning of last year to 11.2% on December 30th. I have looked at the demographics of our agency. 40% of all our employees are retirement eligible, and 33% of them are over the age of 60. So no matter what we do on the recruitment side, we are up against the ferocious tide of our demographics. Another obligation we have is to make sure that companies with employees have workers' compensation insurance, and we are responsible for penalizing them when they don't. We are stepping up our enforcement efforts in response to the most recent audit report covering 2018 to 2022, which found that we weren't doing enough. And I've made a key personnel change at the commission to get that job done, and I'm impressed with the accomplishments of our new director. Speaking of penalties against companies that don't carry workers' compensation insurance, I need to comment and deliver good news concerning SB 216. This bill is pending before your committee, and as originally drafted, requires us to impose a mandatory $25,000 fine on every business we discover to be uninsured, even if the lack of insurance is for one day or for an honest mistake. And I'm happy to report that we have reached an agreement with the UEF to amend the bill to impose a fine not to exceed $25,000. So this restores the discretion of our commissioner. And in fact, it is Commissioner O who is specially assigned to these dockets. And this way she will be able to tailor the fine to the facts. The commission has a medical fee guide committee. I have asked that committee to explore whether a prescription fee guide could be agreed to by a broad consensus of the stakeholders so we can drive down the cost of prescription drugs. Someone most of you know very well, Commissioner and former Senator Alan Kittleman chairs that committee, and he and I will be discussing whether and how that goal might be achieved. We do not have a broad consensus at this time, and Alan and I will have to continue our work on this goal in the upcoming year. I have achieved 2 of my 3 goals this first year. Our agency doubled our courthouse security staff, and we installed metal detectors in our 6 permanent courthouse location. I've seen the deployment of our new computer system in July. It was a rough few months, but our tech support calls are down 85% from the original rollout period. And I want to credit Mary Ahern for her dawn to late night supervision of our contractors for this achievement. We still need to modify some features of the system, and I, along with my colleagues at the witness table, will be keeping a close eye on those needs in the upcoming year. And on that positive note, I will conclude my remarks and I await your questions. Thank you.
Thank you, Commissioner Quinn. Anyone else on the panel like to comment now? No, you're just here to answer questions. Okay, we're going to start with Senator Lamb.
Thank you, Madam Chair, and thank you to the Commission and the Director for all of your work. In my other capacity, I serve as a Medical Director for Occupational Health at a large institution in Howard County, and so we oftentimes see a lot of the handiwork that you do and some of the paperwork that comes back through our medical record charting. So appreciate that. My one question had to do with you mentioned about state vacancies within the Commission, for example, and that maybe a little bit progress has been made, but you still have about 15 vacancies. We've been monitoring vacancies across the board throughout state government, and wanted to get your sense of, do you see continued progress in that regard? At what rate do you think you'll be able to fill some of these positions? Because it certainly probably makes it a little bit more difficult for the Commission to do their work, right? And filling these state vacancies is important. It's a priority for everyone. Wanted to see what kind of the current update is on that.
Well, Senator Lamb, I frequently quote you, as a matter of fact, on this topic because I don't have the quote with me, but something you said in the Daily Record just struck me, which was, we didn't get here overnight, and it is going to take a sustained effort over a period of years to really rebuild state government. And when I was here last year, of course, I was only 6 weeks into the job of chair, but I said, oh, I'm going to have the same vacancy rate next year as this year. I mean, I didn't see a path to progress. But much to my delight and surprise, we have made some progress. But I think the ratio of vacancies is 50% in IT and then 50% in everything else. And that's really the challenge, is that IT component, because every agency is experiencing all the market forces that make IT workers so expensive. And so, unless and until we really address wages and salaries and contracts and compensation of our IT people, we're really gonna struggle.
Okay, thank you. That's a consistent theme we've been hearing across the board for a lot of the cyber and cybersecurity related positions, and it's something that the legislators certainly will continue to look at very carefully.
Yeah, thank you. Thank you.
Thank you, Senator Lamb. And next we have Senator Ellis.
Yeah, thank you. Thank you, Madam Chair. And
good afternoon,
Madam Chair, for
yes.
your testimony. Excuse me. You mentioned in your testimony that there are a number of employers out there who do not buy the required workers' compensation insurance. Do you have any estimate on the type of firms, the number of firms who really skirt the law?
I do. I can't give you an exact number, but I can tell you they're small businesses. I don't know, is 90%, over 90%, is that fair to say, are really small businesses. And oftentimes the mistake they make really stems from when they first set up shop and they went to somebody who said, hey, you should really create an LLC. right? Because that's sort of it's a pass through for tax purposes. But what they fail to tell the new business owner is, oh, that requires you to actually file an exemption with the commission. And if you don't exempt yourself, you're in violation of the law. And so a lot of the cases that Commissioner O hears are people who've made exactly that mistake. And so, you know, we want to, we want to do the right thing, and a fine is necessary, but a $25,000 fine on someone who's made that mistake just feels so inappropriate.
So thank you for that. So the law states a small business who have, say, no employees beyond the proprietor don't need workers' comp. But where is the need for workers' compensation, with one employee or more?
Well, even this small business, a sole proprietor doesn't need to do anything. But someone who owns an LLC or a corporation, they must actually exempt themselves
Okay.
if they don't wish to be covered under the workers' compensation law. Otherwise, anyone who works for a business and receives money is an employee and must be covered.
Right.
Does that answer your question?
Yes, it does. And so what percentage of Maryland's small businesses do you think are not meeting this requirement?
I'm not sure I can answer that. Do either of you have a sense of what that number is? Okay. We're not talking about big companies, but one thing I've noticed is that as the federal government has really cracked down on big construction companies with respect to hiring undocumented workers, what I see from the bench is a lot of these undocumented workers have just started their own little home improvement and construction businesses. And they're all small businesses, but they're all, you know, that so many of them are, they're operating without insurance. So it's a problem we have to get to the bottom of, but it has gotten worse, I think, over the last 10 years.
And if that worker or person in a small business, whether the owner or they bring one or two people on, get injured, they can file a workers' comp claim and they get it through the uninsured.
The UEF.
Okay,
Mhm.
so the system is on the hook anyway, either way.
Mhm.
And so that's why you need this regulation in Senate Bill. That was at 216.
216. Yeah. We don't want it to be draconian, but the fine now is up to $10,000 and the proposal is to make it up to $25,000. But I think UEF Director Burns would agree with me in saying that the bigger problem they have is they have a faulty collection system. So they collect money through the central collections unit, and it hasn't served them well. I would leave it at that.
So why would they need more money if 10,000 is a lot of money, especially to a small business? Why would you need more money to?
They can't collect it.
They can't collect it. So if the fine is higher, you think it'd be more collectible?
No.
Okay, thanks.
But compromise is always good.
Okay. Thank you for your
But part of it, yeah, it's a good question. And I just want to mention one other thing that I had spoken with the chair and the vice chair of this committee about. You know, the UEF did an audit and their own audit said, oh, you're going to be insolvent by FY 2030. And we're in FY 2025. So I had spoken with your leadership about a task force to prevent that insolvency from occurring. And I think Director Burns needs to take that to his board. But we have to focus on this. We have to bring leaders together to make sure this doesn't happen, because we can't have a system where someone falls off a roof and it's a company that doesn't have insurance and they have no recovery. We just don't ever want to become that.
Thank you. I want to pursue that a little
Sure.
further if we can, and it might be Commissioner O.
Mhm.
But I have seen in the experience I had as an insurance agent that a
Mhm.
lot of the general contractors will hire people and have them sign the exclusion form. And in a lot of instances, you can tell they don't write well. They probably
Mhm.
don't know what they're signing.
Absolutely.
And they find out that they are not employees.
Mhm.
They have been set up as an independent contractor. And they don't know that until they either get a big tax bill or they get injured. So how often do you see that kind of independent contractor come to you with an uninsured claim? Does that happen frequently?
You want to take that one? Sure.
We do see that a lot, especially in with construction injuries. But with workers' compensation, we stress that it's not about what the employer necessarily views his employee as. You can label someone an independent contractor. You can have a contract saying you are an independent contractor, but based on facts before the commission, we can still find you as a covered employee if in fact you are a covered employee. And you know, whether the insurance company wants to or not, or the employer wants to or not, if we find that this person is not in fact an independent contractor and is in fact a covered employee, then you will cover this person for this work injury. And so workers' compensation is unique in that respect. There are a lot of people who, or a lot of employers who think they're using independent contractors. And so they try to skirt getting workers' compensation insurance. But in reality, you know, at what a piece of paper says does not matter. It's the facts of the case, facts, you know, that are in the statute and also created by our courts that show that, you know, someone can be in fact an employee, even though everyone else thinks you are an independent contractor.
And here's how they get away with it. They go up to the employee and they say, how would you like to not have any taxes taken out of your check? I go, oh, where do I sign? And next thing you know, they're an independent contractor without realizing what they've done to themselves. In fact, I had this with caregivers. We hired a caregiving company for my father. And I said, I want somebody that has employees. Well, these employees would just harass my father constantly. Why don't you fire this company and I'll come work for you for less and everybody will save money. And so they're just, this whole tax thing is really what they use as the hook.
So Commissioner O, when that happens and you have someone that you make the decision should be a covered employee, is that when UEF pays the claim?
Well, no. Well, if the employer has insurance, because frequently they'll have insurance to cover people they consider who are their employees, and then they'll have others who are independent contractors. And so if we find that they are indeed a covered employee, then they're going to be covered by that policy. And I'm sure their audit at the end of the year will be, you know, roof high. If they are in fact uninsured, then the uninsured employers fund will be on the hook to pay that claim. And then the uninsured employers fund will, I'm sure, fine and assess and,
Okay.
you know,
So they
go
set
do
the
that.
fine, UEF sets the fine.
yes.
Okay, thank you
Well,
very much.
we set the fine. No, we set the fine, but the UEF, they're the ones that I guess go through and come to some type of agreement with the employer, like a payment plan. Hopefully for employers who actually care about it. And then there are those that just don't come to the hearing, don't care if they're fined or assessed, but the commissioners are the ones who assess the fines.
Thank you very much. Do I have any other questions from committee members? No. Thank you very much for your presentation. It's always nice to see.
Always good to see you and thank you for the invitation.
Our next presentation is the update from the Prescription Drug Affordability Board, and we have Andrew York, Executive Director, with us today. Do you have anyone else to bring to the table?
No,
Thank you.
thank you, Chair. I did bring slides that we can present. Great, thank you. So Chair Bidell and members of the committee, thank you so much for your time this afternoon. Thank you, Ms. Kraft. Very excited to be able to present an update on our work and answer any questions that you have about what we're working on. So just for your reference, we want to provide a little bit of history. Actually, I'm not sure that these slides are working. Next slide. Sorry. So we are a small independent agency. We were created in 2019. And our mission is to make prescription drugs more affordable for Marylanders. We have a 5-member board. The chair is appointed by the President of the Senate and the Speaker of the House. And then we have 4 other board members appointed by the President, the Speaker, the Attorney General, and then the Governor's Office. They are supported by a 26-member stakeholder council, which is meant to provide subject matter expertise throughout the supply chain. So there's different members that have kind of different roles that are represented throughout. There's 3 main pieces of work that they do. The first is, I guess I can walk you through the slides on my side if you have paper copies. So we are on page 3. So there's 3 main things that we do. The first thing we do is something called cost reviews, which is an in-depth review of select drugs to determine if they cause affordability challenges. And that basically means that we can kind of pick specific drugs and then kind of look under the hood and get additional information that doesn't currently exist in the public space to actually understand if there are affordability challenges. And I can kind of walk through why, something could look unaffordable to us and then not be affordable in the end. So I'm happy to go into the weeds on that if that's helpful. The next thing that we have is something called upper payment limits. It's a policy tool that was provided to us in our legislation. And that's basically a tool that we have it's one of the most specific tools that we have, but we need to actually kind of develop what that means. And we're doing that through something called our upper payment limit action plan, which I'll cover in just a second. And then the last thing we do is we can provide recommendations around additional policy options. We want to be a resource to you and walking you through some of the complexities of the prescription drug supply chain. So as you consider different pieces of legislation to make prescription drugs affordable, we're here to be a resource for you. We try to give unbiased kind of explainers on these very complex issues. We can let you know where different stakeholders will lie. And we'll try to let you know, here's the impact of your policy, and then it's ultimately up to the policymakers to decide if they want to move forward with that kind of policy. Thank you so much. Great. So I'll go through each of these specifically. The first thing is the cost review process. So again, this is kind of our kind of workhorse policy that we get to implement, and I'll go over the timeline in just a second. But basically, we select from a list of eligible drugs. There's statutory specifications for certain drugs. So drugs that are over $30,000 per year, drugs that increase by $3,000 over the course of a year, biosimilars that come to market that are not at least 15% less than their reference biologic, which is the name brand biologic, or generic drugs that are more than $100 per month and go up by more than 200% over the course of a year. And then the board also had the opportunity to add additional metrics. So they added about a dozen additional metrics, a lot of kind of top 100 drugs from different utilization metrics. So top 100 in overall spend, top 100 in out-of-pocket costs for patients. They added those just to make sure that they're capturing all the drugs that might be most relevant to patients. And then as part of this process, they need to select the drugs for cost review in an open meeting. So again, this allows an in-depth analysis of the different drug, and it allows us to capture kind of confidential and proprietary information that can actually help us understand the issues around drug affordability. I'll mention, we just published something, we published on our website, the board will approve hopefully in this upcoming meeting on Monday, something called our supply chain report, which explains the complexities of the prescription drug supply chain and some of the drivers of affordability challenges. One of the things that it references is the fact that what we see as policymakers is something called the gross spend. So we can see very high spend on drugs. But one of the defining characteristics of the prescription drug market is that all of the discounts come through something called rebates, which are kind of off invoice rebates on the back end. So what you'll hear from both PBMs and then the manufacturers is that certain drugs may look very expensive because the amount that's paid out to the pharmacy is very high, but they say, oh no, don't worry, on the back end, we give this kind of backroom discount to a rebate, so the actual net price is very low. So this process will allow us to understand these issues and understand if there may be affordability challenges with specific drugs. Also, our board is supposed to look at whether or not these drugs, as part of this process, they'll make the determination of whether or not the drug causes challenges for the state healthcare system or high out-of-pocket costs for patients. So they'll evaluate both of those, and if they deem it unaffordable for either of those reasons, they can deem the drug to be unaffordable. So we've passed our regulations that went live December 25th. So we are officially starting this process, which we are very excited about. That's going to be most of our work this year. And there's 5 elements to this process. And I wanted to go through the first 3 because that's what it represents what we're working through in our immediate upcoming work. So first, we need to identify the drugs, and then they ultimately select the drugs. So on the slide with the timetable, here's kind of the key steps that have to happen in open meetings. First, you can see the first PDAB meeting, and we didn't put dates on this, but I can try to put them kind of through the narrative. In the first meeting, the board has drugs that the eligibility list. They have the list of drugs that are eligible based on the statutory metrics and their regulatory metrics. And then also, one of the things that the board created was a mechanism for Marylanders to tell us if they're having trouble affording their drugs. So that's also just a data input to make drugs that the board can consider. So that can happen as early as our January 29th meeting. We've provided a preliminary list of eligible drugs for the January 29th meeting. So the board has this list of the preliminary list of eligible drugs. Then in any subsequent open meeting, we have created something called our kind of a referral process. So our board had the option of kind of being very specific in which kind of drugs they were looking for, or what we ended up going with is a kind of a comment process that allows the board flexibility to address any kinds of issues that might make drugs unaffordable, and then providing a pretty substantial public comment process to allow for the public to notify us their feedback before we just select a drug for cost review. So the way that'll work is in an upcoming meeting, the board will kind of publish publicly the drugs that they are considering for cost review. In that open meeting, they will discuss the list of drugs, and then they will vote on a slate of drugs that they then want to consider for cost review. And this basically opens up the public comment process that I had mentioned. So we have something called our stakeholder council, which is the experts that I referenced before. They will get to weigh in on this slate of drugs that we're considering for cost review. And at the same time, we're going to hold public listening sessions, and the public is allowed to listen in on any of our events as well to provide public comment. And then in the subsequent meeting, the board will then select drugs for cost review. So we've kind of put this additional cost review process on the front end just to make sure that we're getting all the feedback that we can get prior to selecting a drug for cost review. Once a drug is selected for cost review, it comes to the staff, and then we have the opportunity to collect additional information from all the stakeholders. We'll put together what we're calling our dossier, which is basically all the information the board needs to make this determination. And then in a subsequent meeting, the board will then determine whether or not the drug causes affordability challenges. So this is kind of, again, our bread and butter process where we get to do a deep dive on specific drugs. And this is what we'll be working on through a lot of this year. Happy to answer any questions as we go. I know that was a very complicated process, probably a little over-engineered, but we think it gets the public comments that we need. And speaking of public comment, I did just want to outline the different parts where we do allow the public to provide comment in the board's decision-making process. So again, there's the initial kind of anytime we have an open meeting, folks can register to provide public comment. So that's at the nomination section, the consideration by the PDASC, and then also the selection one. And then again, we're doing public-facing information sessions and listening sessions to engage with stakeholders that may be interested in our work. And then also we're always taking written public comment as well that'll be available to the board and the stakeholder council. So that's our cost review process. Again, we expect this to probably start in earnest, probably in our March meeting. So that'll start the kind of nomination process, probably select the drugs in May, and then kind of make their affordability determinations in some of our fall meetings. The other policy tool that we have is the upper payment limits. So our legislation gave us the authority to set upper payment limits for state and local government. So that is state, county, and local employees. So basically those, the health plans for state, local employees, direct state purchases. So you can think of corrections or the health department doing public health programs, and then also the medical state assistance program, i.e. Medicaid. And the way that we do this is through something called our upper payment limit action plan. And this is a document we're putting together right now. And we expect it to answer what drugs would be subject to an upper payment limit, how will we go about setting the upper payment limit amount, and then how would you actually go about implementing the upper payment limit. And our board has done all the work to kind of outline what that looks like. What they've decided is that the drugs that come out of the cost review process and are found to be unaffordable can be subject to upper payment limits, but the board will need to make a determination saying an upper payment limit is an appropriate tool to address the affordability challenges there. So it's just another step to make sure that they're very deliberate in their thoughts of moving forward with an upper payment limit. In terms of how they'll set the upper payment limit, they said that they want basically kind of a bucket of all the different values that are associated with the drugs, so all the different market prices that they have, as well as any kind of data sets on the prices that have been paid for this drug, and then they can use that to set the payment amount. And then finally, this is pretty important. They've decided that they want to implement the upper payment limits through rebates. So it won't affect the rest of the supply chain. It is just going to be kind of reducing the net cost of the drug to the state. And the reason they did this was largely because it's such a specific market. It's a small number of patients that are covered by this. So just to minimize the disruption to the market as a whole, they recommended doing this through rebates. So we're hoping to publish the action plan imminently, as soon as possible. The cycle that we've been working through is having our stakeholder council weigh in on draft documents and then have an updated iteration go before the board. The next stakeholder council meeting is in February. So we're trying to get the upper payment limit action plan out as quickly as possible, and we'll be happy to share a draft as soon as it's available. The last thing that we do is, again, just provide support to policymakers. So again, we want to make ourselves a resource to you as you consider different pieces of legislation. We're always happy to provide additional analysis and research. We do a lot of work on something called the All Payer Claims Database, which represents the commercial population, the Medicaid population, and Medicare population in Maryland. And we're happy to dive into any kind of research questions around prescription drug pricing that you have. So with that, we are at your service and happy to answer any questions.
Thank you, Mr. York. Do I have any committee questions? Because I have a few. Senator Ellis.
Yeah, thank you, Madam Chair. Thank you so much, Director, for your testimony. So the end process of the board, you have a drug on the list and it kind of exceeds the metrics. What do? What will be done to that prescription drug price?
That's a great question. So the way we have framed it is our cost reviews, just based on how the legislation is written, is for the entire state. We want to understand if anyone in Maryland is having trouble affording their drugs. And then a drug can go into that process and we do it in analysis. Again, there's a lot of important proprietary and confidential information that will help us understand if there's actually affordability challenges with that drug. That's all going to be presented to the board in this, probably 20 to 30 page document called a dossier, maybe more than that. And they'll make that determination. And when they say, basically the outcome is they will say we deem this drug to be unaffordable because it has caused affordability challenges for high out-of-pocket costs to patients or something like that. And then they'll give the rationale, like their findings of why they think so. So then that drug will have, had a determination that it is unaffordable. And then that basically opens it up to a whole slew of policy options. One of those options is setting upper payment limits for state and local government, right? So that's one of the tools, but then also there's a number of tools that states can use. A lot of them would probably be recommendations that we would make to the legislator. If it turns out that there's some sort of quirk in the incentive, like weird incentive in the payment system, we would bring that to you and say, this drug seems to be unaffordable because of this. Maybe we want to propose legislation that fixes that quirk, right? So that's, sorry, go ahead.
Yeah, no, okay, thanks for that. So let's say insulin.
Yes.
Price jump really high.
Yes.
And it's unaffordable.
Right.
Would anything that the board does impact the price that the patient would pay at the pharmacy?
It's a good question. So, and again, I again just have to put a caveat that it's a very complex system, and I'll try to keep my answers from getting too far into the rabbit hole.
A yes or no would be good.
Yeah, it will not directly affect the price of insulin for general Marylanders. Our upper payment limits are for state and local government. And so what it will do is it will save taxpayer dollars by reducing the amount that the state pays for the drugs. Medicaid patients and also state employee health plans have very flat co-pays. So the out-of-pocket costs for our initial upper payment limits will likely not impact patient care. It will directly reduce cost to the state. But again, that's kind of the quirk of us setting upper payment limits for Medicaid and state and local
All right,
employees.
yeah, thanks for that.
Yeah.
Thank you, Madam Chair.
Senator Hershey?
Thank you, Madam Chair. I'll just follow on that if I could, Executive Director York. You stated at the very beginning that the, your charge was, again, to make, prescription drugs more affordable.
Yeah.
But then you just kind of responded that that doesn't necessarily correlate to patient out-of-pocket expenses. Is that right?
So great question. So our upper payment limit is for state and local government, Medicaid and employee health plans.
Mhm.
So Medicaid already has like a $1 to $3 copay. And then the state employee health plan has something called a copay structure where it's like a flat $10, right? So just the fact that our upper payment limits are for state and local government make that statement true. We are looking for I also forgot the most important slide that I'll hit at the end. But we have not limited our work to just upper payment limits as the ultimate tool. We've been looking at other things. We have an insulin affordability program where we're trying to partner with manufacturers and get them into copay assistance programs. One of the big issues that I've mentioned is that there's no transparency in this market, which is fundamental to a competitive market. So we're working through trying to put together recommendations on getting the information that everyone needs to actually make prescription drugs a competitive market. And then also we owe an annual report to the General Assembly where we can start to make recommendations on policies. So I would picture us to propose different policies to the legislator that can address some of the issues that you're bringing up now. So again, the upper payment limits is like a very specific tool in the toolbox. There's a lot more that the state can and should be doing to make prescription drugs affordable for Marylanders.
Do you mind explaining the upper payment limits a little bit more? I know
Yeah.
there's a few states that are, well, Colorado is the one that everybody's talking about that's ahead of us. They've identified 5 drugs already. Obviously there was a concern with one of them, but just kind of really explain what that upper payment limit does.
Yeah, so the way in Maryland, ours looks different because we set upper payment limits for state and local government. So what we are doing is basically looking at a drug, then looking at the net cost of a drug, and then if it's deemed to be unaffordable to the state, in this case, because it's for state and local government, we would give the state leverage to negotiate higher, they're called supplemental rebates, to get the net cost to what we think is an appropriate net cost of the drug. So it's going to save the taxpayer dollars, but it otherwise does not affect the rest of the supply chain. That's just how we propose to do it. And that's what we'll be articulating in our upper payment limit action plan. What happens in other states when you have a much larger, again, it's a subset of patients that we're working on, and then also with the insurance design, there's just a lot of quirks with that. If you were to apply it to the entire state, you would potentially look at something like changing the reimbursement amount to the pharmacy. And then if you do that, you need to make sure it flows through the supply chain as you intended to. So that looks probably like the Medicare negotiation.
Yeah, if you don't mind, let's talk about that because I understand that's maybe on its way, or, we're talking about broadening this out.
Okay.
So when you say that, if we're looking at, outside of just the state market,
Mhm.
and again, I want to drill down and find out how this is going to benefit out of pocket costs for the patients. You essentially would be setting the price that a pharmacy purchases the drug for.
There's 3 ways to do it.
Mhm.
Yeah, so one is kind of just set the amount that the pharmacy would receive. Another alternative is change the reimbursement amount, but then also create something called a chargeback that makes the pharmacy whole for like the difference, right? So that's kind of like what it sounds like the Medicare folks will do for the Medicare price negotiations. And then you can also think about a way to continue to do upper payment limits through the mechanism that we've proposed, which is basically just rebates and let the rest of the supply chain stay the same. There's a lot of pros and cons to each of those that you would want to carefully evaluate when you select them.
So when you say the rest of the supply chain,
Mhm.
are you talking about the PBMs and the insurers?
Yeah, there's kind of the distribution side. So there's manufacturers sell to wholesalers, sell to pharmacies, sell to patients. And then on the reimbursement side, you have insurers that hire a PBM to manage their pharmacy benefit. And so when I talk about the supply chain, I'm generally talking about making sure that someone that's acquiring the product is not underwater from any part in the supply chain, right? They want to, if we're changing the reimbursement now at the pharmacy, you need to make sure that they are able to acquire the drug at a lower cost. So they make a margin each step of the supply chain.
So the cost couldn't be, so if you set an upper payment limit, isn't that that is the reimbursement rate then, right?
To the
Okay.
pharmacy, yeah. And then there's
So
ways
the
to
pharmacy
ensure
would
that
be, would the pharmacy be selling it for no change in price at all? No net difference?
It depends on how you do it. Our scope right now is state and local government. So we've decided to do it through the rebate mechanism. If we were to expand, we would probably kind of play out each of those three options that I gave you and then decide which one would be the best for the state of Maryland.
Just a couple real quick.
Yeah.
Again, I mentioned I understand what was going on in Colorado as they picked out a few. Colorado obviously having some very rural areas, Maryland,
Yep.
some as well, not so much, but they are concerned with the accessibility of these prescription drugs. And one of the concerns being, you know, obviously if some pharmacies just decide, hey, it's not worth it for me to carry these drugs anymore if I can't make a profit on them. The other thing is the manufacturers themselves saying in whole, if we can't make a profit on these drugs, why even put them into Maryland?
Right.
Are you concerned with that at all?
For our state and local government scope, I think so part of the reason our upper payment limit is designed the way it is to address the concerns that you've brought up. But then I would just say that, again, the upper payment limit needs to be designed to prevent any adverse consequences that you're talking about. The entire purpose is to increase affordability and access to patients. So I think if there's anything that would potentially decrease access or anything like that, it would kind of go against the mission of the organization. Yeah.
Current law, you guys are preparing a report for us, December 1st, 2026.
Mhm.
And that report is supposed to, I guess, obviously go what you guys have found out and make some recommendations. Should we expand the authority to set upper payment limits? Are you guys working on that yet? Or is it, I mean, I know that's a little ways off, but is there thoughts on where we are with that?
Yeah, we would probably do that after we publish the upper payment limit action plan. So it's certainly, generally a part of the conversation is just kind of as you think through how these are supposed to work, you can think through the different scenarios. So it's not a report that we plan on publishing in the imminent future, but it's something that can certainly, we've done a lot of the thinking on it. So.
Okay, so, but when it talks about recommendations on whether the General Assembly should pass legislation to expand the authority of the board to set upper payment limits, are we in position to do that already? Or, I mean, what would the report in 2026 say to that? Or how would it address
It would
that?
basically lay out the three options that I had mentioned to you and the pros and cons of each, the feasibility of each. There's a lot of operational considerations for each and then also legal considerations. So we can kind of map that out for you as you consider legislation.
Okay, great. Okay,
Yep.
thank you very much.
Yeah.
Thank you, Madam Chair.
Thank you, Senator. Senator Mounts?
Thank you, Madam Chairman. I was checking my Good RX app
Yep.
and talking about this, but getting serious, thank you for the presentation. Back to the board and the work the board's done. So can you just summarize the work the board's done? Your presentation was quick. You covered a lot of information. How many meetings and can you just explain some of the function of the board?
Yeah, so it was created in 2019. They currently meet on a bi-monthly basis, so every other meeting. Our stakeholder council wasn't seated until probably June of 21. I may be a little bit off on that. So I would say a lot of the work really started kind of mid to late 2021. And a lot of that work was creating kind of the infrastructure and policies and procedures on how to do our work. Most of last year was spent developing our cost review regulations, which again were finalized in December of this year. So now we're ready to start our cost reviews. And then also we've worked through the kind of key decisions, the upper payment limit action plan. So I think those are kind of defined. It's just a matter of kind of publishing in a document and making sure that all of our partners across the state are kind of all on the same page as we publish that document. So I would say that's been a lot of the work up to this point. But then again, also we try to serve as a resource to the legislator as well and other our partners throughout the executive branch. There's again a number of policies that a state can implement around prescription drugs that aren't necessarily upper payment limits, and we try to help support that work as well.
So there's a stakeholder group and a board.
A board, yeah.
And they both operate simultaneously. So the stakeholder
Right.
group will be comprised of experts in the field, and then you'll have the board that will adopt or reject those recommendations.
It's the stakeholder council advises, so they basically provide the perspective of the stakeholder group that they recommend. So just as an example, I think there's 3 brand name representatives, 1 generic representative, 1 biotech representative, 1 PBM, 1 insurer, 1 HMO, 1. So it's just like making sure that everyone that can be affected by our work has a kind of a voice, and they advise. So everything, needs to be considered by the stakeholder council, and they provide feedback. So our board meets on 1 month, and then the stakeholder council meets on the alternate month. And we kind of use that as a cycle to have the board kind of propose something, get stakeholder feedback, and then it goes back to the board. Yeah.
And there's a website that goes through all that.
Yeah.
And are there meetings, are they open hearings, or do they just have meetings and then report?
Yeah, everything is public.
recommendations?
They're all public meetings. Most of them have been remote since COVID, but we are hoping to go back to in-person. And if we go to in-person, then we'll go back to live stream and then allow for synchronous participation. So folks that can't attend in person can certainly attend remotely.
And you mentioned rebates.
Mhm.
I've had some discussions about rebates. When rebates are taken into consideration for affordability, is that just, who actually benefits from the rebate? Because it's been explained to me in certain situations where PBMs actually get the rebate, the consumer does not. How do you evaluate that, and how do you synthesize that in what you're reviewing as far as whether a prescription drug is affordable or not?
Great question. So in our supply chain report, we actually walk through an example of how perverse the calculations are when you include rebates. Drugs,
excuse me, what'd you say?
are in our supply perverse, like they creates very, very weird incentives.
Okay.
The rebates, yeah. Ultimately, if you talk to insurers and PBMs, what they say is they are getting a low net cost of the drug, and they come to the insurer in the form of rebates, which is almost like a slush fund that they can use for whatever they want. And what they often do is they often use those to buy down premiums. So they actually keep premiums artificially low, which is like maybe a good thing, right? Like that's almost
Right.
ultimately a policy choice as well. Is like, how do you want to use this slush fund of money? You can use it to keep everyone else's premiums low, though then you have a situation where the sickest patients are functionally subsidizing the healthy patients, where like theoretically insurance is supposed to be the opposite, the healthy kind of like pool funds to then, if you have an unfortunate accident, then you have the protections against that. So that's just like that's a artifact of how this system works. You mentioned kind of PBMs. One thing about that system is that it just, I would say, puts no accountability anywhere. Like we have no idea how much I call it the net cost of a drug, like how much a drug actually costs. So when we talk to a manufacturer, we'll say, hey, look, this is like a very expensive drug, and we're sending all this money to pharmacies. And then what they say is like, oh, actually, don't worry about it. The net price has stayed the same for the past 10 years. It's just this list price and gross spend that's been going up, but we just give it all back to the insurer through rebates, right? So one, we can't validate that. We have no idea. And like, we just kind of have to take their word on it. But then two, it creates, again, this slush fund, and you just have no idea how anyone's using it. So PBMs might pocket some of it, insurers might pocket some of it. It might be used for administrative costs. It might be used to buy down premiums, but you just have no idea how that's used. So it just creates a very weird market, I would say. Yeah.
Right. And didn't that system sort of develop or evolve in the process of bringing a new drug into the market? Isn't that part of the process right now, how some of these novel drugs make it into the market that are available? The more, I guess you'd say, the cutting edge drugs, and maybe it's a marketing scheme or whatever to get them prescribed, but they're more costly, and it's a way to sort of an operating model, I guess, a business model for how we get these different medications to make them available.
Yeah. So I think what you're referring to, so usually when a new drug comes to market in a class, like you have 3 drugs in a class, they're all competing on rebates. So they all will actually go up in list price, and you'll see more money spent on those drugs together as a new competitor comes to market. And then what's happening is they're competing by giving larger rebates back to the PBM to get onto the formulary and push volume. What you might be referring to is like there's some like manufacturers will tell you, I've tried to reduce my list costs, and the insurer will choose not to pick it, right? They'll have something called either an authorized generic, or you can have multiple drugs, and they'll have one that's a high list price, high rebate, and then low list price and no, like little to no rebate. And the insurer chooses the more expensive one, like literally the exact same drug, and they have two different NDCs. So that just like, again, shows the potentially perverse incentives of this system. So that might be what you're talking about, where there's a decision the manufacturer needs to make of like, am I going to be a high price drug and then give a big rebate back, or a low price drug? And they often have to choose to be a high price drug. That might be,
Yeah, it's a confusing topic. I could
Very
ask you
confusing, yeah.
questions about it for a while, but you helped shed some light on
Yeah,
some of the things that came to mind with your testimony. So
Great.
thank you.
yeah, keep us on speed dial. We're always happy to walk through this, and we can put together visuals and stuff like that.
Thank you, Senator. Senator Reedy?
Thank you very much, Madam Chair. Thanks for the presentation, because I had voted, I'd had this bill, but I wasn't on the committee when it passed. And
Mhm.
so there's a lot of things a few things I remember, but a lot of things I didn't. So that's good. I've got I may bounce around a little because I had several things I was making notes on. One would be the testimony from the public when you're in the middle of the process.
Mhm.
Kind of who vets that? Because we want to hear from the public, but I don't know that anybody's going to come from the public and say this drug is totally affordable, don't make any changes.
Yeah.
And there are drugs that spike, and there are good reasons to ask questions. Does that go back to the stakeholders for feedback as well? Do the stakeholders come and give public testimony? How does the process work at that instance?
So we're still building out exactly what the listening sessions look like. And you bring up a good point, because what we've heard from other experiences, so CMS, for example, went through a comparable process for their negotiations. And they had a public session where it was kind of just everyone jump in, right? Patients, prescribers, like manufacturers. And it seems like it's worth kind of separating at least the patients in particular, just to make sure, because they're often sharing very personal stories that are related to disease states and things like that. So it may be worth keeping patients separate. But I would say we certainly want feedback from everyone. There's like, I think everyone in the supply chain, including, for example, manufacturers, are probably going to be the most affected. So we want their feedback, and we want to, have a good faith conversation. In terms of the vetting, that's something we can consider. And I think we've heard stakeholder council members bring up this concern, because we also have a process where folks can just email us and say they're having trouble, right? And I think what we
And by the way, I'm sure they're telling the truth, they're having trouble. I
Yeah.
just mean, how do we
Right,
kind of
right.
quantify it? Yeah.
Well, then also it brings up an interesting question that we've thought through a lot of, like, for the patient, when does a patient decide a drug is unaffordable, right? It can be, there's like income considerations and things like that. So, but I think what we are doing is just including it as a data point with the caveat that, this has not been validated. Just kind of take this for what it is. Often they're required to provide contact information so we can follow up with additional questions. And from what we've seen, I'm not sure that it's been like overwhelming feedback. So we'll see kind of the volume. It's going to be a learning process. I think that's certainly one thing to say is our cost review will be a learning process. So we'll see how it goes kind of for this initial round, and then there are probably going to be some lessons learned from that.
Kind of continuing that vein, we have the stakeholder group. Who appoints the stakeholder
Yeah.
group?
I don't know exactly who does what off the top of my head, but the governor appoints a third, the president of the Senate appoints a third, and the Speaker of the House appoints a third. But like, I forget exactly the allocations. I can get that for
So
you.
the way we have it is we have a 5-member board.
25-member board, yes.
They're appointed by 5 different parts of
4,
state
yeah,
government,
yeah,
or 4,
yeah.
4. And then 3 different parts of state government
Yeah.
are appointing the stakeholder board, but it sounds like there's some designated spots for insurance.
Right. So,
PBMs,
so it'll
consumer.
look like the president of the Senate can name a brand name manufacturer, a generics manufacturer, a PBM manufacturer, a nurse, and a physician. And then the governor's office gets to do a brand name manufacturer, biotech industry. Like, it's just, they each have their,
Is that all spelled out? I know
Yeah.
I know it's all statutory, including the stakeholder group.
it is. And I should
Okay.
have provided
No,
that.
that's
It's one
okay.
of the slides we
can-
have. Yeah.
It's been a few years. That's
Yeah,
right.
yeah.
I guess some concern that as I've been looking more and more at how this is actually going to work, some concern that I have is the accountability of the
Yeah.
board to the public and to the voters, because obviously, I mean,
Yeah.
voters elect a governor and they elect state legislators, and we elect our presiding officers, and they elect an attorney general, but you're going to have this very massive group of people making a lot of pretty not life and
Yeah.
death, but certainly close to life and death decisions, possibly life and death decisions. I don't know if, and this is not, you don't need to answer this, right now in the hearing, but I'd love to know if there are ideas of how we can make sure that we keep some level of accountability in the system. Because it's, pretty serious, pretty serious, responsibility, and it's a big group of people. There's been talk about, you're going to release a preliminary list of drugs. When will that come out?
We're tentatively scheduled to start that process for our March meeting, so we would probably publish at least 2 weeks in advance of that. And so the way that works is each board would on their own kind of nominate drugs off the eligibility list that they are interested in for further consideration. Our eligibility, the list of eligible drugs is pretty substantial, so we wanted to make sure that the public is paying attention to the drugs that the board is considering.
So the board members will nominate the eligible drugs?
Yes.
From the list of eligible
Yeah.
drugs. Our current board, is there anybody there that actually works in prescribing or pharmacy or?
Yeah, so we have one physician, though I think he may be retired, so I'm not sure if but has experience prescribing. And then we have our chair is Van Mitchell, who is previous legislator and health secretary,
Right.
knows the
Yeah.
how to run an organization, which is very good. And then we have 3 health science researchers, all very esteemed in their field. Jerry Anderson and Joe Levy from Johns Hopkins and Aberia Nokoga from the University of Maryland
Okay.
School of Pharmacy.
We don't have anybody, and I know it's only 5, but we don't really have anybody who has experience in the business side of pharmaceuticals, or frankly, on the business side of having a large contract for drug coverage for employees outside the public sector, correct?
I mean, not outside the public sector. I would say
Because
that
right now
our
it only
chair-
impacts the public
Yeah, our
sector,
chair
yeah.
certainly had experience with that.
Okay.
As like a small
Right.
business, and then
Okay.
also as a health secretary.
Okay, and Madam Chair, thank you for the patience. Could I have just one more question, then I will move on. We'll move on. Yeah, so there are, in some of the other states that I've read about, because we're going to be considering other ideas here this session, there's been concern raised, I think, in both Colorado and Michigan that I've read about, maybe other places about. There are the concern about forcing insurers, either forcing or insurers steering patients to drugs that are more generic, even though they may be dealing with some drugs. Some drugs, there are lots of generics available, which is great, but there are some drugs that are very, very special.
Yep.
I don't know how many of the current eligible list are considered specialty versus things that may be considered later. What's the safeguard against watching out that, one, we don't steer people to where they can't go to their local pharmacy because there's not enough selection, or that the pharmacies now cannot get the drug because it doesn't meet the right price limits for them? And how can we safeguard against that? And also on the insurance side, making sure we don't have insurers that might just, for cost purposes, steer people away from a drug that may be working for them.
Yeah, that's a great question. So in my mind, I've separated those into 2 separate buckets. I guess that could certainly be a concern as a result of upper payment limits, but it's also just an issue in the whole health system as a whole. Like if it's an issue in the health system as a whole, then theoretically it could apply to upper payment limits. So I almost put the issues that you've described, and we outline them in our supply chain report, and think that there are important issues that should be addressed as like separate legislation or separate policies that a state would want to implement. I mean, I guess you can address them in the process of setting an upper payment limit, but it's not necessarily like I would consider it a separate issue. Yeah.
And Senator Lamb.
Thank you. A question for you. I guess this kind of falls on the transparency kind of umbrella. I've been looking at some of the minutes here for the PDAB, a little bit sparse. And so I think some of these recordings, some of the meetings are being recorded.
Yeah.
Is it possible to put the recordings online so that people can view and go back to see what actually occurred?
I'd be happy to bring that to the board. It was a board decision probably early on to publish minutes. I can certainly take it back to the board though.
Okay, would strongly encourage the board to
Great.
take a look at that, because
Thank
if
you.
these recordings are there, I don't see why they can't be put online.
Great.
this is to, I think, Senator Ellis's point earlier that he was making, you know, and also I think Senator Mouts had brought this up too, when it comes to rebates and making sure that the end user in all of this, the consumer, is ultimately the folks that need to benefit from this, that we hear and continue to hear from a lot of constituents that are concerned about co-pays and high deductibles and insurances that are, you know, continue to be increasing. And our concern is that making sure that these savings actually reach the end consumer and are not eaten up by profits elsewhere along the chain, whether it's by payers or PBMs and the like. What can you do to help ensure that? And is there a better way to track the actual dollars being put out by consumers for these costs? And is that something the PDAP can track to actually give us a real metric to see we're doing all this work, but is it actually affecting what the consumer and our constituents are paying at the end?
Right. Yeah. And so great question. Thank you. So I would say that again, I feel like it may have been misrepresented that I said our work is not going to affect copays. Again, that's a characteristic of the fact that Medicaid and the employee health plan don't, like, they have flat copays, right? I think as soon as we, and that like our upper payment limit applies there, the board made it clear that that's their priority too, is to make sure that any savings is passed on to the patient. So as soon as we would be doing any work on like an insurance structure that had co-insurance or deductibles and things like that, we would make sure that those savings were passed on directly to the patient. So I think that is a very high priority for the board. In terms of the transparency, that's kind of the goal of our transparency program, is to understand exactly who's making what throughout the supply chain and ultimately what the patient is paying. One of the limitations we have is we do see what the out-of-patient, like the patient responsibility is in the all payer claims database. But what we hear often is that it doesn't capture things like copay assistance programs and other things that aren't necessarily captured in the APCD. And these are all things that we think are very important, actually understanding if there's an affordability challenge. Folks have referenced the Trikafta experience in Colorado, and basically what they found is like it's an extremely expensive drug, extremely high copays, but then almost all patients said that they had enough access to patient assistance programs that it was affordable for them. So they deemed that drug to be affordable basically because the manufacturer, like, you know, could pay the copays or the co-insurance of all the patients. So that's like an issue that we want to be able to understand just from the data rather than having to kind of take that from everyone. So I would expect our transparency program to outline all the different things that we need from all the different stakeholders. And then we would hopefully bring it to you in a future session to consider it as an option. But we agree that that's an important element, is actually understanding who's making what, and that would get rid of a lot of
well, and using the same metric year after year for
Yes.
what the end user, our consumers, our constituents are actually paying,
Yes.
and being able to demonstrate that that's actually going down.
Absolutely. Yes. No, that's a great point of actually measuring our work to see impact. Yes. I'm sorry, I misunderstood the question. Yeah. I come from the CMS Innovation Center where we were running models, and every model had to have like there was an entire team just evaluating the effect of the model. And I hope to take that lens here. Like, we have limited resources, but I do think we always want to understand the impact of our work and study it as much as possible.
All right, last question for you. A few years ago, I had a bill that was passed to create a rare disease advisory council. Because there are a lot of rare diseases out there that oftentimes don't get the attention that they need. Sometimes these rare diseases have drugs that are very expensive, right? And so the question for you is, how can we ensure that that these drugs remain to some extent affordable? Obviously, they're very rare, so they're very expensive, without impacting innovation, particularly in the rare disease space?
It's a great question. And our board kind of struggles with this all the time. This is kind of a quintessential conversation around work on drug affordability and drug pricing, is how do you make sure that you continue to incentivize innovation while also ensuring affordability? And a lot of this can be based on things like insurance design. I would just say that our board is required, or I think they put in their regulations that they will consider if it's an orphan drug or treating a rare disease. So it's a piece of information that the board will have, though they don't have to, we haven't prescribed what they have to do with that information, but I would certainly say that it's, in the interest of the board to, continue to make sure that we're, incentivizing innovation in the space and while also ensuring access.
Great, thank you.
If there are no other questions, I have one or two, just easy ones. After all that, these are the easy ones. Will the supply chain report be on the website?
Yeah, so we have our draft published now. It should look basically like what is going to be published on Monday. So I can
Okay.
share that. I would say the executive summary is the most useful part for you.
And the list of select drugs, will we be able to see those?
That will be available. We're targeting our March meeting, so it will be
Okay.
available probably 2 weeks before our March meeting. I'm happy to send a notification as soon as published.
So it really sounds very complicated when we start talking
Yeah.
about rebates and manufacturers. But am I right? The Medicaid schedule is based on NADAC?
So Medicaid reimbursement can be very complicated. We're an MCO system. And then we also have a fee for service segment for certain drugs, drug classes. In the fee for service segment, I understand that it's actual acquisition costs, which is like a state specific NADAC plus a dispensing fee. It's a pretty substantial dispensing fee. I think you probably saw that report.
20%, right?
Yeah. And then the MCOs function closer to a normal commercial prescriber. So they kind of set their own payment rates and own dispensing fees. So I would say part of Medicaid reimburses on NADAC. There are efforts to move away. So the issue with the kind of way everything works now, which I would call the MCO model, is that pharmacies are losing on some drugs and then making margins on other drugs.
Mhm.
And it just creates, again, then you start driving utilization to the drugs that you're making the highest margin on. You try to avoid drugs where you're losing. There's obviously like a lot of complaints from the pharmacies about being underwater on certain drugs. If you move to a NADAC model, which is basically your actual acquisition cost plus a dispensing fee, it does kind of clean everything up. And there are certain insurers that are trying to use that as the new model. And that kind of gets rid of things like rebates and stuff like that too. So,
Thank you.
Yep.
No other questions? Thank you so much for your work. And I will tell, if you haven't tried to call Executive Director York, you'll find out he's very accessible and very helpful. Thank you for being here today.
thank you.